I want to look at XD's comment from session 7 on genealogy. Specifically, the context is that before XD's comment at 1 hour and 5 minutes and 10 seconds, we were talking about the difference between a expressivist approach and a genealogical approach. So here is the video.
I think that's a great start for us here. Changda, do you want to build on that?
It's just a separate thought. I feel like probably also somewhat connected is that I think that the core purpose for like expressivism and this genealogy is fundamentally different. Like I feel that expressivism is that how like laws they can convey like social meanings and attitudes and all that. But then building on that, what it means that we can kind of like analyze how laws are suitable for certain like social norms and all that. So it's more focused on like the investigation of laws. But then I feel that genealogy, on the other hand, is more of like methodology to perceive law. That's why I think that in the earlier comment, I would say more that instead of like saying that like genealogy is reading law through the lens of expressivism, I would say it's the other way, that expressivism is kind of about adopting genealogy when we look at law. So I'll say that that's I guess the difference. I'm not sure if
You're going to write it down now. You get to write that down because I want to track it.
So, with XD's comment, what he's doing is he's applying distinguished definitions by saying that expressivism is a perspective, whereas genealogy is a method. So, in that sense, you can't really say that expressivism is like what led to genealogy, but rather the other way around, which is that genealogy is a particular method of examining law, and expressivism is an offshoot of that method. However, I think I would tend to disagree with this because, well, once again, when we look at genealogy and expressivism, the primary difference that we've identified is that genealogy talks about the process in which the law came to life, whereas expressivism talks more about the future of the law, where it goes, what impacts it has. That goes into the considerations of whether or not a law is just or correct or we should implement it. Whereas a genealogy doesn't, I feel like it does not fully make an argumentative moral argument for the existence of a law. It merely says this is how we approach it, this is how we understand it. The issue, as I also mentioned in class, and the main distinction I think, is that genealogy is very dependent on the person applying the genealogical approach. What type of morality do they have that they then add on to whatever sort of whatever question they're looking at, right? So that is the primary difference. So again, doing distinctions definitions, but to a deeper extent. The second in-class comment I'd like to address is Camila's sort of response to mine in session 8 when we're talking about customary law. I made the argument that it feels like there doesn't really need to be a need to actually create customary law because it should only apply to that sort of community, right? So making it into a recognized sort of like institutional, constitutional law, it just feels like it's going a step too far. And this is her response.
Camila, go for it.
First to what Jerry said, I was thinking that the problem is that sometimes customary law clashes with, like I can think of specific examples in which customary law clashes with constitutional law, and constitutional law is always going to win, but having, like in the hierarchy, but then if you put customary law sometimes, like in the constitution, sometimes it would be, like, okay, an example is like, I know that in certain national parks, certain people that have this indigenous title, as in the Napo one, they're able to hunt, and this is something that it would be illegal for them to do if it wasn't in the constitution, that they are, because of their a group of an indigenous group, they are able to do so. And this is what I wanted to say at the beginning, because I think we were being a little harsh into, yeah, they're very like hazards and dangers of having customary law written down, but at the same time, there's things that we're living in a post-colonial world in which like there's too many customary laws that might have become a constitution pre-constitutions existed in those certain parts of the world that are being overlooked, for example, or like that have to coexist with these constitutions that were written. So I don't know, I think that there are also benefits to it.
So she goes sort of deeper, specifically pointing out that in a post-colonial world there is that difference in sort of like customs that existed before the Constitution and so on. So there are times where customary law clashes with constitutional law. So my sort of perspective would be to come from this from a perspective of legal authority, in which we question what power the government has in terms of the customary law and the constitutional law. So it is only when sort of customary law is being applied to others or affect other people that clashes occur with constitutional law, or when constitutional law tries to override it. So I can actually see an argument of why we need and don't need customary law to be recognized, to be legalized and fulfilled. An argument against the recognition and legalization would be that if this does not reach other groups, if this does not reach other sort of like societies and communities, then it's fine for a little community to just have a law for themselves. An example I think that I typed out later in class was that you could just say that my family has these laws, these customs. We do not apply it on other people. It is just for us. That is our customs, but it does not need to be customary law. However, once the overreach occurs, once sort of either the government creates constitutional laws that goes against our customary laws, or our customary laws goes against constitutional laws, there is that conflict, and that's when you actually need the legalization and finalization. The point of customary law needing to be constitutionally accepted and formalized is that it is a matter of scale, right? We have the constitutional law as an overarching, all-binding agreement, sort of similar to a social contract perspective, that regardless of what customs you have, you are under. The problem is, people, many cases, members and groups don't have a say in what type of community or society they become a part of, especially the government, especially if they're marginalized groups. So for the state to sort of be accepted, for the state to be legitimized, it has the legal authority and the legal responsibility to its constituents. So in the cases where an administration just suddenly changes or shifts their policies or ideals, there needs to be written laws that serves as a record of particular groups, agencies, and rights to maintain their customary laws. Without that, well, governmental overreach can go so deep and so far that it essentially, again, disrupts the trust and destroys the sort of balance that is created when you have the different levels of governance, when you have sort of more freedoms for particular parts of the government, and so on and so forth. So there should be barriers to what norms are considered customary laws, what considerations we go through that allows some customary laws to coexist with constitutional laws, and to what extent do constitutional laws have power over individual communities' laws. The first producer comment I'd like to talk about is quite a long one from Casper. This would be session 7, when we're talking about Foucauldian genealogy. Specifically, on this comment, the context is that we have been discussing sort of the process of genealogy, of how it is talking about the changes through the past that affect the present, that constitute what the present is. So for Casper, he tagged actually #challenges here, which I'll read now. I wonder if a contemporary example of this, tied to the explicatum from Carnap, would be the evolution terminology used to describe trans communities, especially in medical contexts. Namely, there have been efforts, although directly disrespected by many, to move away from the pathologizing, exclusionary language to include the conceptual scope of gender identities. Standards of Care for the Health of Transgender and Gender Diverse People notes that the best way of approaching TGD people is to ask how they would like to be addressed in terms of name and pronouns, their gender identity, and the language that should be used to describe their body parts, statement 1.3. With that, Chapter 3 directly states that definitions applied to TGD population are variable and stresses that self-identification may lead to discrepancies in understanding medical history of TBG people that may mislead diagnosis. Example given are blood samples, which may differ based on hormonal medicine taken. And with certainty, I stand fully for the shift that advances recognition and respect of human experiences. And on that basis, I understand that Knopp's earlier claim that when a numerous words are used to cover a concept such as self-understanding, its intended function, here inclusivity, may create ambiguity. And I would challenge that still in application, this may not be negative as the reading framed. For example, terminology such as male to female is still used in medical contexts, but its usage has been stressed as discriminatory by trans community. Hence, changes are adapted to places such as Wikipedia, where the definition of a trans woman changed to a woman who was assigned male at birth, with broader umbrella concepts stressed late, including non-binary experiences. Thus, I challenge whether the lack of clear definitions over gender identity terms aimed at increasing a TBG patient's autonomy is inherently negative, as the reading implies, even when considering that medical documentation still uses terms socially deemed improperly. So this is a rather large consideration, and I'd like to first agree with Casper that yes, there is issues with the definitions used in medical documentation when addressing gender identity. The issue, as he points out, is that fully distinct definitions are not inclusive enough for everyone, right? If we were to say that, just having a whole umbrella term applies for every single person in the situation, it might not actually be that applicable, and it would not be useful in sort of medical procedures and such. So how do we reconcile that difference between what is actually being used in medical procedures and used in legal text, and what the community believes to be acceptable and correct? I actually believe that there is sort of a miscategorization of assumptions in this passage. Foucault's genealogy does argue for the process of understanding current values and positions through a historical process and lens, but that is not an assumption that says that understanding sort of, the current definitions parameters needs to be very strictly constrained. As a matter of fact, I'd say that the underlying assumption here actually argues in the opposite. By saying that there is a long process of growth and change, the Foucault's genealogy actually would say that, yes, there are many cases in which definitions are not standard, in which there is not clear structured lines in which you are defined, or this term is defined to be something exactly, but rather because of how the idea has changed through history, there is differences in sort of definition. There's differences in how we interpret it. The main argument that Casper is challenging is that concept and practice often conflict. And I would make the argument that that is an implicit assumption of Foucaultian genealogy, that for said conflict to be resolved, we need to examine the intertwining of concepts and social practices. Right? We see this in medical terms. We see this in terms where terminology has changed. Queer, for example, was a derogatory term in the late 19th century in the US, but was reclaimed by the different communities as an empowering and inclusive label. So if we adopt Foucaultian genealogy, it stands that the medical definition terms will adapt and grow into the expected use of modern society. The final comment that I'd like to look at is Hilary's from the session 10 pre-class work, specifically when talking about the matter of judicial review. So in prior parts of this reading, there was a lot of discussion about whether or not judicial review actually helps democracy or hinders it. Hilary, her comment is this: Initially, I found the idea that limiting majority power can actually strengthen democracy rather than weaken it a bit counterintuitive, because it seems like majority rule should define democracy. However, this part helped clarify this, as the authors seem to be saying that without limits, majority rule could undermine the equal status of some citizens, which could contradict the idea of democracy as collective self-governance among equals. I think the key insight here is that democracy is about maintaining a system where everyone's interests are treated as equally important, even when they are in minority, instead of just aggregating everyone's preference. So, there's a very important implication here that firstly, the school constitutionalism do not follow a consequentialist view, which is sort of very against what Waldron's arguing for. So his arguments in this section that is addressing that, that's pointing to that as a point of critique, would need to be looked at with a grain of salt. Second of all, there is a deeper consideration of what type of society sort of this would create, in which democracy serves primarily as a way to ensure everyone's interests that are treated equally, and judicial review works more as a mechanism to place constraints upon the system to prevent a tyranny of the masses. However, with sort of a deeper kind of implication is that if judicial review has such power in this situation, one that overrides sort of the decisions of elected officials, then this might be too much power to a particular sort of governmental agency, and too many degrees of separation between sort of the ones who are deciding on policies, who are acting on its legitimacy, and the people. Furthermore, sort of going back to prior sessions, I think like session 3, session 4, actually just 1 to 4, when we're talking about the power of judges, the roles of judges, especially session 4 on interpretism, there is a further implication that by giving the application of law, by giving the consideration whether or not this is legitimized to individuals, well, we're not avoiding the human factor in the application of laws, especially if those people who are sort of treating laws, who are dealing with laws, could be influenced by the other branches of government, whether it is through the bribery, through appointment, many other ways. There is a deep connect that could exist between the judges and the people. So, this may not sound like that big of a deal, but if we were to take this even one step further, we have to consider the effects of a society in which judicial review is so far removed from people that it makes people feel distrustful towards the judicial branch, the executive branch, all branches of government. And the less trust they feel, the less, justification new laws and decisions are going to have. So even though there is ostensibly protection against governmental overreach and a protection of fundamental rights, a lack of trust will only serve to diminish the democratic system and cause potential democratic backsliding.